the Senate Judiciary Committee will come to order. We have one member substitution today. We want to welcome Senator Francisco, sitting on committee for today only, March 7th, 2022, for Senator Haley. So welcome again to committee. With that committee, then, we will open the hearing on Senate Bill 541, and it has a long, short title, so I will let the reviser then take care of that for us. So, Mr. Thompson with the bill brief. Thank you.
All right. Thank you, Madam Chair, and good morning, committee. As you mentioned, Senate Bill 541 does have quite a long, short title. It's not very short, but that's because there are a number of pieces in here. And so to keep things brief, I'll just try to highlight some of those pieces. You may notice in the bill brief, it's fairly long, and I've done it out of order. It's not numerically necessarily, it's more by topic. So we'll kind of go through it that way, and then we'll see if you have any questions for me. So Senate Bill 541 has several changes to laws related to the umbrella of public health and contagious or infectious disease. The first new section there requires compensation for use, restriction on use, damage, loss, or destruction of property as a result of certain governmental actions. There is a comparable provision to this in the Kansas Emergency Management Act. That section is KSA 48-933. I'm pretty sure that's the right number. I apologize, I didn't bring that up with me. But this is modeled on that KEMA provision, except that we add the restriction on use aspect, right? So the compensation that can be provided can be based on a restriction and not a full commandeering or damage or loss, which is what it's limited to under KEMA. I do note that the definition of governmental action is fairly specific here in the section. It's an order, resolution, or ordinance related to a contagious or infectious disease issued or adopted by the state, county, city, or other political subdivision of the state that mandates the wearing of face masks, limits the size of gatherings of individuals, restricts the operation of business, controls the movement of persons, or limits religious gatherings. So that's the universe of topics that you're considering governmental action under this section. And I'd also note that compensation would be provided based on similar provisions in the, and I want to get the name right, in the statutes for condemnation actions under our KSA 26-501 statutes. So there would be a similar, a usage of similar law that's already on the books for condemnation actions. And that's how you'd figure out what compensation would be done here. All right. I think that's it for new section 1. And again, there's a lot more in the bill brief and the bill, so I'm trying to keep it a little shorter than normal. The last thing I would note on section 1 is it does only apply to governmental action taken on or after the effective date of the act. So it is not retroactive to actions that have already been taken. New section 2 then provides that a city ordinance or action related to contagious or infectious disease that relates to mass gathering of individuals, et cetera, those same topics we were just talking about, those ordinances or actions shall not exceed 30 days in duration at a time before they have to be renewed or they have to expire. If you're an aggrieved party, you may file a civil action in the district court, and within 30 days after the issuance of that ordinance or adoption of or action that was taken. So you have 30 days to file your claim. If you're an aggrieved party, the court is required to conduct a hearing within 72 hours, and the court will grant the request for relief unless they find such order was narrowly tailored to the stated purpose and uses the least restrictive means to achieve such purpose. The court is required to issue the order without unreasonable delay after the hearing and shall award a prevailing plaintiff the cost of the suit, including reasonable attorney fees. For most of you, that will sound really familiar with a couple of changes because that is similar to the provisions you enacted in Senate Bill 40 last session. And so that's why I grouped these sections here. This new section about cities is similar to the judicial review and civil action provisions that are in these other sections in the bill that we're amending later on. So section 6, we have KSA 48-925. That is the judicial review of certain executive orders issued during a state of disaster emergency. Section 7 is 48-925C. Those are certain actions taken or orders issued or policies adopted by the Board of Education of a school district. Section 8 is 48-925D. That's related to actions taken, orders issued, or policies adopted by the governing body of a community college or a technical college. And Section 9 is KSA 48-932. That's certain actions taken by a local unit of government during a state of local disaster emergency. Again, that's under KEMA, just like, but for local emergencies rather than statewide. And finally, Section 14, which is KSA 65-201. That's the certain orders approved by a board of county commissioners and issued by a local health officer. So again, under each of those provisions, there is a procedure for aggrieved parties to file a civil action, and then there are mandatory timelines given to rule on those actions by the court. I do note that in each of these sections, much like in Section 3 that I was just talking about, that current law is maintained, but it's also changed in two ways that I'll highlight. First is that rather than requiring the court to issue an order within 7 days, or the hearing is deemed, or the petition is deemed granted, the provision is just changed to say that the court should act without unreasonable delay. So that 7-day provision requiring a ruling within 7 days is eliminated in each of those sections. And secondly, a provision is added in each of those places to award a prevailing party, a prevailing plaintiff, the cost of the suit, including their reasonable attorney fees. So those are the two differences from SB 40, and those are also reflected in that new Section 3, which uses that same model, but applies it to cities and local actions. All right. So the next thing I want to highlight, since I've mentioned Section 7 and 8.
Committee, let's go ahead and stop if we have any questions for the reviser up to this point. Senator Corson.
Thank you, Madam Chair. Is aggrieved party defined anywhere in this, in 541? Like who is an aggrieved party? Thank you.
Okay. Mr. Thompson.
Madam Chair and Senator, no, there's no definition. It has the general meaning used in legal actions where you have to assert that you were aggrieved in some way, and the court will either find that you are an aggrieved party that's allowed to be a plaintiff, or they'll find that you're not aggrieved, or that you don't have standing and you're not allowed to maintain the action. So it's left up to the normal civil action rules.
All right, Senator Francisco.
Thank you, Madam Chair. I'm looking at the part of the bill that allows or requires conducting a hearing within 72 hours, and I think that's for the Board of Education and for a court. What happens if that's on President's Day weekend and the court is not meeting for 72 hours?
Mr. Thompson.
Madam Chair and Senator, so that's the provision that I'll remind everyone is expressed not only in the new section on cities, but also in Section 6 and 7 and 8 and 9 and 14. It's in several places, right? We have this procedure where whoever the acting entity is, if they issue one of these kinds of orders that we've been talking about, they are required to limit those, first of all, to not to exceed 30 days. And then they're also required to allow an aggrieved party to file an action challenging them within 30 days after the action was taken. And then you get to the provision that the Senator was just referring to, that sort of notwithstanding that the court may be closed or under some special rules adopted by the Supreme Court under KSA 20-172, the court shall conduct a hearing within 72 hours. And as the committee may remember from last year's discussion on Senate Bill 40, this is the same kind of language used in the habeas proceedings for an order of quarantine or isolation. So up in KSA Chapter 65, we have this 72-hour hearing concept, and that's been replicated in all of these places. So if the court I'd have to look at the rule again on if the court is closed for business when that ends, what happens. But I think it's left to the court is always in some way open within that 72 hours. And so this is presented to them and they have a deadline and they have to meet it. And if they don't, then we've got an issue that the court did not have the hearing or it needed to delay it for some reason. And so you get into that management of the court docket, I guess, is where I have to leave it. The statute's not perfectly clear on that. And one of the potential problems that we heard about in the case that went up on appeal related to Senate Bill 40 was that not only was there a 72-hour hearing requirement, there was a 7-day issuance of opinion requirement. That part is removed, right? So at least if the court has some reason to move the hearing and doesn't do it quite right within the 72-hour period, they're required to, without unreasonable delay, pursue issuing the opinion. The idea being that this is a very expedited process, and the court will have to manage that accordingly. I know that's a roundabout kind of lawyer answer, but the statute just doesn't get into it more than stating 72 hours and then leaning on lots of other rules that apply to courts and managing their dockets.
Mr. Thompson, there are other areas of Kansas law where we have in place 72-hour hearing requirement. Could you identify what those are?
Sure, Madam Chair. So the one I was referencing in particular a minute ago was in Chapter 65, and that's when you have an isolation or quarantine order. So if you are required to go to isolation or quarantine for a public health reason by the Secretary of Health and Environment, you have a right to appeal that essentially with a 72-hour hearing, and that's where this concept is borrowed from.
Thank you. Senator Francisco.
Thank you, Madam Chair. But it could be true if this, say, applies to businesses, that there would be more than one party aggrieved, and then the court would have to manage that series of dockets all within the 72 hours.
Mr. Thompson, I think the answer is yes, but go ahead, Mr. Thompson.
Madam Chair and Senator, yes, the answer is yes. And I will only say that in each of the provisions, there is the final subsection or the final paragraph of each of those. And I'll just highlight the one on page 4 because it's the one I'm looking at in line 6, right? The Supreme Court can adopt emergency rules of procedure to facilitate the efficient adjudication of any hearing under this subsection, including but not limited to rules for consolidation of similar hearings. So the idea is that the Supreme Court, who issues all the rules for the lower courts, and the district courts will sort of collaborate and find a procedure that will allow, say, consolidation of 10 similar hearings where they could do that if they had 10 aggrieved parties. So it attempts to contemplate that, but also defer to the court's management of the court's operations so that we don't run into issues of separation of powers. I think that's maybe a fair way of putting that.
Thank you, and let's continue with the bill brief then.
Very good. Thank you, Madam Chair. All right. Circling back very briefly to sections 7 and 8, just because I highlighted that there's a change to the judicial review process. There's another change in those sections that I feel like we need to highlight here. Section 7, again, is the one about the Board of Education. And right now, this section only applies during the state of disaster emergency related to the COVID-19 health emergency. So that has been declared over, that state of disaster emergency has expired. So in theory, this section has no operation in law currently. But that changes under the bill because it is amended to provide that only the Board of Education has the authority to take action on these issues of contagious or infectious disease that affect the operation of their schools or attendance centers. And so they would be given that power at all times, not just during a state of disaster emergency or during the one that already expired. And there's a similar amendment in KSA 48-925D, which deals with community colleges and technical colleges. It grants those governing bodies of those institutions the authority to take any action on contagious or infectious disease that affects the operation of their community college or technical college. And further, if they do take that action, they are limited to 30 days in duration, just like a city or a county in other places in the bill. So those changes are added to the current law. The authority that the legislature said was their sole authority during that disaster emergency becomes their sole authority at all times. And any other entity that is attempting to impose an order or take an action that affects the operation of those institutions with regard to contagious or infectious disease has to defer to the authority of that governing body instead. I kind of glossed over that a little bit, but I wanted to highlight those changes in there. Then shifting back to schools, since we're still on that topic, we can shift back to new section 3, which deals with K-12 and actually not just K-12, I apologize, K-12 and post-secondary educational institutions, and prohibits school officials from issuing or requiring use of a COVID-19 vaccination passport or discriminating against a student based upon COVID-19 vaccination status. So this would be a new provision in the law that applies to post-secondary educational institutions, the State Board of Education, local boards of education, schools, and school officials. So all of them are covered by this section. And they're prohibited from doing 3 things. First, they shall not issue a COVID-19 vaccination passport to any individual without such individual's consent. Second, they shall not require an individual to use a COVID-19 vaccination passport for any purpose. And third, they shall not refuse access to education or a place accessible to the general public, or separate an individual from others based on such individual's COVID-19 vaccination status. And I note that the violation of that would be a Class A non-person misdemeanor. Again, only about COVID-19 vaccination status and COVID-19 vaccination passports. So it is limited in that regard. Sticking with schools, new section 4 then deals with exemptions from face mask mandates. So if a school district or any school building or activity thereof requires some or all students, district personnel, or visitors to wear a face mask for any reason, the student, the district personnel, or the visitor with a medical condition or with religious opposition preventing the wearing of the mask shall not be required to wear it if they present one of 2 pieces of documentation. 1, a written statement signed by a physician or a parent or guardian, or by the person if they're over 18 themselves, stating that their physical condition is such that wearing a mask would seriously endanger the life or health of the person. And second, you could present a written statement signed by a parent or guardian or the person themselves if they're over 18, stating that wearing a mask would violate sincerely held religious beliefs of the person. The provision that you may be familiar with from your special session bill, the legislature special session bill, is here, stating that a person shall be granted the exemption requested based on sincerely held religious beliefs without inquiring into the sincerity of the request. So essentially it's presented and it must be honored. You're not allowed to question the sincerity of that request based on religious beliefs. And anyone who does present one of these certifications or pieces of documentation shall not be denied enrollment or full in-person participation in the school activity because of that action, and they also shall not be segregated or separated from other individuals because of that action. So again, this is a provision just about face masks and those statements that you can present in order to have that requirement waived if a school imposes those requirements. And I note that this is based on the provision amended in section 15, KSA 72-6262, which requires schools to recognize exemptions from vaccination requirements. So that same concept for vaccination requirements already in current law is modified and applied to face masks in new section 4. So I'll highlight that and then maybe pause again before we shift topics. The immunization provision in section 15 basically under current law just requires you to have certain immunizations, and if you have a medical or religious exemption request, you're given 2 ways that you can present documentation to have that waived and still be admitted to the school. This would keep those current provisions and but change the religious belief aspect to require rather than the current law to require that you can have a statement that the test or inoculation that you're trying to get a waiver from would violate sincerely held religious beliefs, and then also say that you're not allowed to inquire into the sincerity of that request. So that change is made to the current law, and then a new provision is added to state that if the certification is for an exemption for an inoculation or test that does not have final approval by the Federal Food and Drug Administration, the requirements are a little bit looser. You're allowed to present a written statement signed by not just the physician, but also by the parent or guardian that says you have a medical reason for not taking this vaccination. And you can also submit your religious exemption similarly. But so there becomes two provisions, right? There's one for things that have FDA approval and one for things that do not have FDA approval. So there's sort of 4 different pieces of documentation potentially that you could provide. I also note that the similar non-discrimination provision is added there, that they cannot deny enrollment based on just filing a certification, and they cannot segregate or separate individuals based on that action either. So that wraps up kind of the school portion. If you want me to pause again, Madam Chair, I'll see if there are any questions.
Sure, we will pause briefly for any questions. Any questions for the revisor? Senator Pyle.
Thank you, Madam Chair. Jason, on the religious exemption, having to sign, what if I'm an agnostic, have no religion, and or at least believe I don't have a religion, and I don't want to, I don't have anything to sign as a religious exemption? How do I get an exemption from wearing this mask or a vaccine or whatever?
Mr. Thompson.
Thank you, Madam Chair. And Senator, thanks for highlighting one of the things I skipped over. This is the danger of going through not everything that's in there. In each of those places where we talk about religious beliefs, we also use the definition of religious beliefs that you enacted in the special session bill that defines that more broadly than traditional theistic and non-theistic beliefs, right? So it includes, but is not limited to, theistic and non-theistic moral and ethical beliefs as to what is right and wrong that are sincerely held with the strength of traditional religious views. So it's more of a conscientious objector sort of standard, as you guys discussed in the special session. That same language that allows anyone essentially to assert something that is held with the strength of a traditional religious view and assert that as a religious belief under the terms of those exemptions.
And where is that, Madam Chair?
Yes, I was going to say, I see it on page 5.
Sure. The first example, Madam Chair, thank you, is on page 5. So this is that new section about masks specifically on page 5 in line 23. There's the definition of religious beliefs. And that is replicated in section 15, where we have the immunization provision. And there might even be one other place I'm not thinking of right now, but for sure in those 2 places, that definition is added so that the broader concept is in there.
Senator Pyle.
So then, Madam Chair, why are we not using right of conscience language instead of religious beliefs? Why that direction?
That would be a policy decision of the committee.
What if, Madam Chair, and Jason can answer this if you can't, but what if I just plain don't believe the science that says that the mask prevents me from getting something communicable, and that because I don't, and I believe it's unhealthy to wear that mask, that it's a better health benefit? I know I have a lot of people that said they would rather build their immunity system up and face that challenge. What if that's my belief? It has nothing to do with theistic or non-theistic. It has nothing to do with those, but I don't want to wear a mask, period. How do we cover that?
Sure, and I have heard from Kansans who have those same opinions, and they have their reasons for not wanting to wear a mask. And looks like the bill addresses those as well. It's not limited to any theistic or non-theistic moral or ethical beliefs as to what is right and wrong. Simply, if you believe, according to the definition that's in the draft, Mr. Thompson can correct me if I'm wrong, that ethical beliefs as to what is right and wrong. I mean, that's kind of, I think, as basic as we can get to kind of a conscientious objection as well, to cover the broad gambit of you don't have to be a parishioner at any particular denomination. It's meant to be broad to cover instances like you're raising, Senator.
I'll stop for now. Thank you.
Other questions? Seeing none, then go ahead, Mr. Thompson.
Thank you again, Madam Chair. So then shifting away from schools and then to a few sort of the miscellaneous topics that are covered on the last couple of pages of the bill brief. Section 10 is KSA 48-961, and that is your COVID-19 Contact Tracing Privacy Act, enacted in a couple of sessions ago. So notwithstanding that this expired on May 1st of 2021, the provisions of the section are going to be reenacted in force and effect on and after the effective date of the act. We don't make any substantive changes to the Contact Tracing Privacy Act. It still only applies to COVID-19 contact tracing, for example, but the date is changed so that it is revived from expiring in May of 2021, and we continue going forward. Section 11 then shifts to the powers and duties of the Secretary of Health and Environment, provided in KSA 65-101. We add a new provision here that requires that if the Secretary takes any action related to contagious or infectious disease, that mandates masks, limits gatherings, restricts business operation, controls movement, or limits religious gatherings, it has to do two things. It first has to be narrowly tailored to the purpose of the action and use the least restrictive means to achieve such purpose. And second, it has to not exceed 30 days before it expires or has to be modified or renewed. So those same provisions that are applied to cities and other actors are applied to the powers and duties of the Secretary of Health and Environment, although there is no judicial review provision provided for the Secretary of Health and Environment. So that's the difference there. It is that they are still limited with the scope of their order on those issues, and it still cannot exceed 30 days, but there is no judicial review provision. Again, a policy choice that was made in prior sessions, but is continued in the bill here. Then Section 12 gets into KSA 65-119. That's the powers and duties of the county or joint board of health or local health officers. And all that's done in that section is to make two references to the restrictions on those powers that are provided in 65-201. You recall we talked about 65-201 just a little bit ago. The changes in that section say that if a local health officer recommends and a board of county commissioners enacts an order or an ordinance or a resolution or anything that impacts one of those contagious or infectious disease areas we've been talking about, that those are all subject to judicial review, they're subject to 30-day limitation, all of those things. And so there's just a reference in this statute to make sure that they know those same limitations apply here to their broader powers. And then shifting to the last couple of sections, there's KSA 65-122 in section 13, which deals with schools and child care facilities and denying access based on infection with a disease that's suspected of being infectious or contagious. There's a new provision added to that statute that states no person shall be denied access to a public, parochial, or private school or licensed child care facility unless there are reasonable grounds to believe that such person is actually infected with a disease suspected of being contagious or infectious. So there's a current law provision that says you're not allowed to admit these folks that are suspected of being infectious or contagious. And then there's a new provision that states there needs to be reasonable grounds to believe that they are actually infected and not some other basis. And then finally, I'll highlight section 16, which is the tax provision, KSA 79-1614. In last session, the legislature enacted a provision that authorizes reimbursement of property taxes. So for any building listed and assessed for property taxation as real property that maintains a business on the property that was shut down or restricted by the state, county, city, or other political subdivision pursuant to an executive order issued by the governor under KEMA, KSA 48-925, or issued by a local political subdivision under 48-924 or 932, again, parts of KEMA, they can make application to the Board of County Commissioners in the county where that property is located for the reimbursement of property taxes levied on that property during shutdown or restriction. So that's your current law that you enacted last session. The expansion here is that you would also be authorized to seek reimbursement of property taxes levied on your business shut down or restricted as a result of any action taken by a county, city, or other political subdivision of the state related to contagious or infectious disease pursuant to Chapter 65. So if the reason your business was shut down was a contagious or infectious disease order by the Secretary of Health and Environment, for example, that was not related to an emergency declaration, you would be subject to this provision and you would be allowed to seek compensation of your property taxes for being shut down for that purpose. Again, the current law does not allow that unless it's related to a disaster emergency. This would expand that to allow it in more circumstances. I note again that it would only apply to actions taken on and after the effective date of the act. So it's prospective only. This would not go back and apply to anything that's already occurred. And for purposes of when that date would be, the bill would take effect on publication in the Register. So whenever that occurs would be the effective date of the act. I think that covers nearly everything. I skipped over a couple pieces, but I'll see if you have any last questions.
Thank you. Committee questions for the revisor. Senator Thompson.
Just one quick one, and I don't know if there's a good answer for this or not, but talks about narrowly tailoring these decisions. Is there any kind of guidelines for that? Because I mean, narrowly tailored could be very broad. That's my concern.
Narrowly tailored is a legal term of art, but go ahead, Mr. Thompson.
Madam Chair and Senator, thank you for the clarification. Yeah, the chairperson is right. It sounds a little broader than maybe it is in case law. Case law dives into narrowly tailored restrictions and least restrictive means and all of those tests frequently. So there's a lot of case law to apply on those topics, and that's why we're leaning on those terms, is to give the court something they're familiar with, and the litigants, for that matter, something that they're familiar with, and should have a lot of case law behind applying that standard.
And it looks like the way it's written that they shall provide the relief unless it's shown that it's outside of narrowly tailored, or correct?
Mr. Thompson.
Madam Chair and Senator, yes, that's correct. So I'm going to look at one of the current law provisions just because I want to give you the exact language. Let's see. Probably the best example is the one in 48.925. At least I hope that's the best example. Right. So the current, again, this is in several places, enacted in Senate Bill 40 last year. So the current provision in KSA 48-925, which deals with when the governor issues an executive order and you have an aggrieved party, the top of page 8 has the current law provision. The court shall grant the request for relief unless the court finds such executive order is narrowly tailored to respond to the state of disaster emergency and uses the least restrictive means to achieve such purpose. And that similar language is kind of echoed in the other provisions. Again, leaning on the concept of the plaintiff has presented that they're aggrieved. If the court agrees that they have standing, they are an aggrieved party, etc., they shall grant their request for relief unless they can find that whatever action was taken is narrowly tailored to respond to the issue that was presented and uses the least restrictive means to achieve that purpose. So it is essentially not exactly a rebuttable presumption, but almost shifts the burden at that point, right? You say you're aggrieved by it and can show that you have standing, then it's basically on the party taking the action to show that what they did was narrowly tailored and was the least restrictive means. Otherwise, the court has to grant the plaintiff's case. And under the provisions of the bill, they would further have to grant costs and attorney fees to the plaintiff for bringing the suit, which is a new provision that I just thought I'd mention while I was on there again.
Just one little.
Sure, go ahead.
So say the governor or the health director or whoever makes this order, and they say they're relying on the CDC, for example, but the litigants brought some other testimony that refutes that, the court would have to weigh the option. My concern is what we saw is that everybody relied on the CDC and no other information or testimony was considered. That's my only big concern here.
Go ahead, Mr. Thompson.
Madam Chair and Senator,
This basically sets up, if I'm correct, strict scrutiny if if an executive order, for instance, is going to be reviewed by a court, it is under the standard with the narrowly tailored and uses the least restrictive means. That is essentially strict scrutiny standard, which is the highest level of scrutiny that a court can apply to governmental actions or other actions. Am I correct in that, Mr. Thompson?
Madam Chair, yes, that's generally what we would consider strict scrutiny when you're analyzing a constitutional action, a civil action on constitutional grounds. So to address the secondary issue that was just raised about sort of the balancing of evidence or the weighing of evidence, that is the court's role as the trier of fact to consider all the evidence presented by both litigants, both parties, or more than two parties, by all the parties, and then make the decision about whether what the purpose was, whether it was narrowly tailored for that purpose, and whether it was the least restrictive means of achieving that purpose. And if they find that it was, that's the decision in the case. It's subject to appeal, et cetera. And if they find that it was not, they award the plaintiff the relief that they're seeking. So but it is up to the court to decide those issues, yes.
Okay. Thank you, Jason. Thank you, Madam Chair.
Thank you. With that committee then, thank you for that very thorough bill brief, Mr. Thompson. We do have, by my count, 7 in-person or via WebEx conferees today, 7. So in order to answer questions that the committee may have for the conferees, we are going to have 3 minutes of testimony from each, and I will provide, as best I can, a 1-minute warning of 1 minute time remaining. And with that, then, we will ask the first proponent in-person conferee, Mr. Eric Stafford, Vice President of Government Affairs, Kansas Chamber of Commerce, to come to the podium. Please introduce yourself and welcome to committee.
Thank you, Madam Chair and members of the committee. Good morning. Happy Monday. My name is Eric Stafford, Vice President of Government Affairs with the Kansas Chamber. I'm here really just to speak on sections 1 and 2 in support of Senate Bill 541. Those are the sections that are dealing with businesses that are shut down or used, as the definition says, under pandemic. I think last year we had a lot of conversations on some deficiencies that we learned about and saw. I know there will be some attorneys who will be speaking shortly who have been involved in litigation representing businesses in the state who were closed but felt like they could safely open and protect their customers, but local governments prevented them from doing so. Last year, you all passed Senate Bill 273, which created the Small Business COVID Relief Fund. That was unfortunately vetoed. There were some, I think, problems that the governor's office saw in that bill, and we were, not that they were opposed to the concept behind it. I think that probably led to the generation of Senate Bill 541, and the business provisions here is fixing some of those problems, looking on a prospective basis through some of the work that those involved last year on variety of policies have kind of worked to put together. So happy to save the rest of my time for those individuals and answer any questions at the appropriate time.
Thank you. And committee, we will reserve our questions till we've heard from all the proponent conferees. Next, we will hear from, this name is familiar from last Thursday, but I don't have the first name, Karen Barth. I'm sorry, Carrie. Yes, there you go. Thank you. Please introduce yourself and welcome to committee.
Hello, Chairman Warren and distinguished Senate Committee. My name is Carrie Barth. I'm a resident of Baldwin City, Kansas, and I live in Douglas County. I'm here as a proponent of SB 541. I have 2 high school daughters, a senior and a junior, and only one of them has had a normal high school year. From the initial notice from Baldwin USD 348 school lockdown in 2020, where we were 100% online and our kids only had access to Canvas, which is a glorified electronic bulletin board, and it was up to the kids to reach out to the teacher for help. Kids had to self-teach. They fell behind, which goes against our No Child Left Behind policy. School year 2020-2021 was a hybrid or online videos only option. Then Kansas Governor Kelly passed the Back to School Act, March of 2021, that required all Kansas schools to offer an in-person 5 days per week learning option. Every school in the entire state of Kansas returned to 5 days per week continuous learning, except for Baldwin USD 348. Our school opened the doors for all 5 days, but remained teaching in hybrid manner. I called the Kansas Board of Education and spoke with Commissioner Nineswander asking questions, and Commissioner Nineswander called USD 348 superintendent to confirm that this is what happened. Our kids had to suffer on multiple levels from a decision made by our administration and our board. Kansas Board of Education had reported to Governor Kelly that every single district had returned full-time. However, that was incorrect, as USD 348 did not. The definition of emergency has been abused in the state of Kansas. Douglas County Commissioners has continued the abuse of mask mandating, calling it an emergency mask mandate. There is no emergency. We have seen this same type of abuse of emergency across the globe and in other countries. It has become trendy to overuse the word of emergency. It is a disgrace and it goes against our freedoms. I have a daughter that will be a freshman this coming year at a university located here in the state of Kansas. And so I want this law to apply to this too, for both public and private universities and colleges. And I asked about their COVID testing policy, vaccines, contagion, contract tracing, quarantines, etc. I wanted to speak with the president who makes these decisions, but I was transferred to the DEI, which is their Diversity, Equity, and Inclusion Department.
1 minute.
So at all levels. I have also 2 little nephews and a niece that are kindergarten, pre-K, and 1st grade in Lawrence, Kansas. For the first time in Douglas County, Kansas, masks have not been mandated, and for kids under 12 and under. It's sad. This should concern us all. My nephew's teacher told my sister, only after 3 days of not wearing a mask, what a difference it makes for her to be able to see her kids' faces and for them to see their teacher's face. She said the amount of learning that they accomplished in 3 days was so much greater than they had accomplished all year, and that she realizes how much it's going to take for them to make up this loss in education. These mandates on children have done so much harm, and it's not okay. At this point in time, it's becoming a form of child abuse. I'm asking you to uphold our Kansas and United States constitutional rights of freedom. I'm tired of government overreach. I'm tired of local government not listening. I'm frustrated. The harm to children makes me sad. And I still keep shining the light on truth and what is good, and will continue to do so. Thank you so much for being a part of the committee, hearing and listening to us. It feels really good to be heard. And I look forward to watching what you all do in session going forward. Thank you.
Thank you. Next, we will invite Ryan Kriegshauser with Kriegshauser Nye Law Group. Please introduce yourself and welcome to committee.
Thank you very much. Ryan Kriegshauser from Kriegshauser Nye Law Group. I think the committee's heard a lot of the frustration that has been pent up over the last year, here over the last few days. I think Senate Bill 40 gave a lot of parents a voice, but what we have found over the past year of litigating a lot of cases, and I don't want to spend a whole bunch of time talking about our cases, but I'm happy to go into any of them if anyone has questions. But what we have found is that units of government, particularly counties and school boards, are willing to basically use any loophole they can to get around some of the SB 40 requirements. I'll give you some examples. Here in Shawnee County, for instance, we had a local health officer that just issued PDF forms to quarantine students. So any administrator at a school, a principal, not even a medical official could just fill out a PDF form, and it already had the local health officer's signature on it on the PDF when it was issued to the school. They issued hundreds of quarantines, and that went into court, and Judge Watson here in Shawnee County said, you can't delegate this authority to quarantine children and put them under house arrest for 14 days with a PDF form that who knows who is actually filling it out, and that's going up on appeal. We found in Morris County, they issued an indefinite mask order. It had no end. And of course, if you don't act within 30 days, you have no right to bring an SB 40 hearing. Johnson County issued an order that lasted a greater part of a year. And Douglas County started issuing 60-day orders. So if they could just get past that first 30 days, then they couldn't be contested. So we have seen counties repeatedly find any way they can to circumvent the things that you've put into place. And I'll note to your point, Senator Thompson, no court has found that these orders aren't narrowly tailored. That's why we're going up on appeal in Morris County. So there is a concern. I think you have a legitimate one because some of these courts are looking at even an indefinite mask order and saying, yeah, it's narrowly tailored. And the school board hearings were, in many ways, a farce. They'd appoint an administrative officer and they'd say, oh, it's a mask mandate. That's probably the narrowest, the most narrowly tailored thing we could do. So I'm happy to go into those, but this bill is kind of a conglomeration of the issues that we've come up over the last year in litigation. So happy to take questions to talk about any of those cases. Thank you.
Thank you. And we will need paper copies from Ms. Barth and Mr. Kriegshauser for our committee folders. If you have those in the committee meeting room at this time, we're happy to distribute those. If Ms. Barth, you have yours as well. Committee, we also had proponent written only testimony submitted with a PDF. We don't yet have paper copies submitted by Megan Harper, Sarah McMillan, and Carrie Sue Vosberg, all private citizens. So their testimony can be found online. We do not yet have paper copies submitted. With that, are there any other proponent conferees in the committee meeting room or on WebEx? Yes, seeing a hand, sure. Please introduce yourself, and do you have written copies of your? Okay, great. Ms. Nelson will take that. Thank you, and please introduce yourself and welcome to committee.
All right, I'm Gavin Weedle from McPherson High School. Get it started? All right.
Go ahead.
All right. Good morning. Today I'm here to tell you about an incident that happened to me on September 10th, 2020. At this point in school, we have had masks on this whole time, and I hated it. When I got to school that morning, everything was normal. I was doing fine, but I just knew something wasn't right. I just couldn't figure out what it was. Roughly 30 to 35 minutes into class, I woke up on the ground looking up at one of my coaches, nurse, principal, and my dad. I was unconscious, but here's how the story really goes. I was sitting at my desk, and all of a sudden, I kicked my friend in the back. At the same time, he turned around to ask me why I did that. My teacher told me to stop playing around. Then from across the room, a classmate yelled, "He's having a seizure." My teacher ran out of the room, leaving me seizing with no adults, only students who did not know what to do. I was left banging my head repeatedly on the desk and slid out of my chair onto the floor, where I continued to bang my head. There was blood everywhere. While the teacher was out of the room, a classmate ran to get help. He ran into my coach, who finally took the mask off my face that was holding in spit and foam, causing me to aspirate, which could have led to my death. My coach stayed with me until my parents, the school nurse, and some teachers arrived. After hearing all the things that had happened to me during this time I was having the seizure, I asked myself, am I safe? Does the school really care about me? Can I trust them? I was mad that I was humiliated in front of the entire school, as they were put on a soft lockdown because of the situation that could have been prevented. Most importantly, no one should be discriminated because they were wearing a mask, because they don't want to wear a mask or not being vaccinated. Schools should be obligated to recognize all exemptions, particularly those by parents. A parent knows their child's history the best and should know and should be able to make decisions for them. Lastly, I would like to mention the fact that there is not any seizure training provided at my school. I am more likely to die from a seizure than from COVID. If my teacher was provided with the training, I would have sustained far less injuries. It took much longer for me to recover from this seizure due to the mask on my face. I think it's time for the schools to think about what's the best interest for our kids instead of mandating masks, vaccines, in spite of what the CDC says. Thank you for giving me this time to talk about my concerns and share my story. I trust that my experience will create a positive change in our near future. If you guys have any questions, I can answer them later.
Thank you. Committee, then, we will open it up for questions for our proponent conferees. Yes, Senator Gossage.
Thank you, Madam Chair. I guess this could be for Ryan Kriegshauser.
Ryan Kriegshauser, yeah.
Yes, on page 4, line 14, when with regard to notwithstanding any provision of law to the contrary, post-secondary educational institutions, then it goes on to say, shall not issue a COVID-19 vaccine passport to any individual without such individual's consent. I'm trying to understand how that would ever happen.
I'm sorry, what was the end of that question?
I'm trying to understand how that would ever happen. How would a college give someone a vaccine passport without their knowledge or consent?
Thank you for the question, Senator. Ryan Kriegshauser from Kriegshauser Law Group. This section primarily comes from a budget proviso that you all passed last session, which I'm sorry to say has been totally ignored by schools and counties in many ways. So a way that this has worked in practice right now is a school will come up with a quarantine policy, but if you're vaccinated, you don't have to quarantine. But if you aren't vaccinated, you have to quarantine for 14 days. And so it's basically depriving education based on vaccination status. And that's the way we've seen it play out in counties. I think Johnson County did this as well for a time. If you're an unvaccinated employee and you had a close contact, you had to quarantine for 14 days. Whereas if you were vaccinated, you just go on as if nothing had happened. And so they're basically policy de facto vaccination passports, but it's more using the policy to treat people differently based on their status.
Thank you. And one more, Madam Chair, for the young man who just testified, if he's still here. Could you come up to the mic?
Yeah.
Your name again?
Gavin Weedle.
Gavin, thank you so much for being here and the courage to tell your story. You're not the first story that we've heard of young people who have had difficulties. Did you feel you were treated differently in the classroom?
How? Like, what do you mean by that?
So you were wearing a mask.
Yeah.
Did you feel that you were treated any differently because you decided not to have a vaccine?
Definitely in the first year of COVID, when we first had this whole thing, because I was one of the only ones in the school walking around without after we had pushed and pushed and pushed for a exemption, but they just didn't give it to us, and we warned them that it could happen, and if it did, I could have died. Luckily, I didn't. Yeah, after we got that exemption, after I did feel a little bit, segregated from that. I was having to sit away from everybody, and a different side of the classroom because I wasn't wearing a mask.
Thank you. Thank you, Madam Chair.
Thank you, Gavin. If you'll answer one more question, I want to echo the comments from Senator Gossage. Thank you for having the courage to come today and tell your story. It's a story that I myself have heard in different ways many times throughout the last year or two. And you had mentioned you had to sit in a different section of the classroom or you had to eat lunch in a different place. Tell the committee a little bit about that.
Okay, yeah. So wherever I was so I was still in the classroom, but everybody at this time was, about, what was it, the 6 feet or 3 feet or whatever apart because of the COVID. I was having to sit in the back corner of the classroom, and then everybody else was still over about, I don't know, you could say 12 feet away.
Was this because you were choosing to not wear a mask?
Because I didn't have the mask on.
And was it also because of your vaccination status with regard to COVID-19?
At that time, early stages, I don't think the vaccine was out yet.
Did that happen later on once the COVID-19 vaccine was out and it was known that you hadn't received
by
it?
that time, a few other people in the school started getting, that was when the religious exemptions were coming out. But yeah, we still had to sit farther away.
Thank you, committee. Yes, Senator Gossage.
Thank you, Gavin, and thank you, Madam Chair. One more question. You said you were trying to get an exemption. Did your doctor write a statement to submit to the school?
Yeah, that was the difficulty. We were trying to get an exemption from my neurologist, and he wouldn't write it for us. And this whole time we were trying to get the exemption, we asked the school if we could have it off of me, but they still wouldn't allow that while we're trying to get the exemption. So the neurologist said you'll have to ask the primary care doctor. Because apparently it didn't pertain to epilepsy. So we asked the primary care doctor, and they said the same thing. They sent us back to the neurologist. It took me having the seizure for them to realize, oh, it could actually kill him. So they finally took it off.
Thank you, Gavin. Thank you, Madam Chair.
Thank you again.
Yep.
Committee, other questions? Senator Pyle.
Thank you. My question's for Mr. Kriegshauser.
Sure. Mr. Kriegshauser, would you come back to the podium? Thank you.
Yes, sir. Thank you. Based on some of your comments on the narrowly tailored language, I guess my question would be, this bill is full of adjectives, reasonable and unreasonable, using that adjective as a marker. That's a very vague statement to put those words in there. Would you define what you have found the actions of governmental entities as being reasonable or unreasonable?
Well, thank you, Senator Ryan Kriegshauser, Kriegshauser Nye Law Group. One thing I do want to mention before I get to your question, based on the comments we just heard, one thing we have seen a lot of is medical professionals being turned in to the Board of Healing Arts based on their positions. And so there is some legitimate fear from medical professionals, even granting mask exemptions when they are obviously appropriate. But the doctors don't want to be turned in. They don't want to have to fight it out in front of the Board of Healing Arts. And there are people who actively seek out doctors who give exemption to do exactly that. So that's something for the committee to be aware of. We've experienced that and seen that happen. But to your point, no, I'd say the point of SB 40 and our approach this entire time has been trying to get governments and units of government to act reasonably. But as you can see from things like Morris County, an indefinite mask order that goes for a year is not reasonable. Units of government should come back, and you hear it all the time. The science, follow the science, but units of governments want to fire and forget. Basically, let's issue this mask order. That was painful. Thank goodness we don't have to do that again. And after 30 days, there's no SB 40 procedure to make them revisit it. Units of government should be reviewing this constantly every 30 days. And what are the case counts now? And I know it's painful, but that's why county commissioners get elected, to make those kind of decisions. So if they want to run for office, it's not, they weren't just stuck in there. They actually pursued the office. So they should have to make these decisions and come up every 30 days. And that's what this bill does. It doesn't allow the unreasonable action like a county like Morris County that just issues an order that never ends. They have to revisit it.
So follow up, so yes, their actions could be deemed unreasonable, but would those governmental entities also probably or likely deem the actions of the people that don't want to just comply, would they deem their actions reasonable or unreasonable?
Well, I think that's a good point, and that's why we focused on due process. There should be methods for, the parents here who are frustrated to have an independent body listen to their position. When parents are getting hundreds of quarantines here in Shawnee County because the local health officer decides to issue a PDF form, there should be an avenue to go to court, and they did here. And Shawnee County District Court said, what are you doing? You can't do this. You can't just delegate this authority. And so that's why there is that back and forth, and we've tried to find a balance throughout this and advocate for a balance so that you can have those. These are policy discussions that shouldn't just be wielded like so many school boards have done without any back and forth.
And just to follow, I believe you are around for special session. I offered an amendment that no employer in the state of Kansas could do certain mandates without express consent of the legislature. That amendment passed in the Senate and it was stripped off by leadership for whatever reasons they deemed reasonable or unreasonable. But to me, Ryan, this goes to the heart of the matter because we've got a bill here that if we had that law, we're here for a purpose. And when governmental entities want to start putting things in place that they deem reasonable, I believe we should be called back and the people should be heard, not just the governmental entities. And we should be making those decisions because we are elected to represent the whole state. So if we've got an emergency that affects the whole state, and I know the business entities, the governmental entities, any employer, that's what the amendment was for. No employer could implement a mandate without express legislative consent. It was that simple. Wouldn't that resolve this bill?
I think a lot of the things the bill is trying to resolve is like the 30-day period, things like that. The budget provisos that were frankly ignored, and school districts argued that they didn't apply because I guess they said that they didn't get a direct appropriation. But there were aspects that the legislature did pass that were totally ignored, where school districts put in place what I think violated Senate Bill 159 in that budget proviso. I think counties did the same thing. And so I think this is to cover up, fix a lot of those other things as well. And so we tried to make this more expansive to close some of those aspects as well.
Thank you. I will just leave the committee. And we have a prime example today of government out of control, and that's Mr. Putin. We see what can happen when government wants to mandate their will upon people. And we see that today. It's being played out before us. Yes, maybe that's not the best example, but that brings it home. We need to elect leaders that have the worldview that is based upon what our founders believed, and that the rights and the liberties of the people are protected. I don't know that narrowly tailored or reasonable or unreasonable in this bill is appropriate anywhere. We need to make sure it's strictly defined so that this doesn't happen. I'll end with that. Thank you, Madam Chair. Thank you, Rod.
Thank you.
Thank you, Mr. Kriegshauser. I have a follow-up question to the senator's questions. We see in the opponent testimony opposition from, quite frankly, local units of government, the League of Kansas Municipalities, Kansas Association of Counties, Kansas Association of Local Health Departments, a particular local health department, a different particular local health department. And what is your response when we are hearing opposition from the units of government to a bill like this that seeks to protect freedoms and liberties of individuals and Kansans? Do you have a response that you would like to share for the committee and for those listening, and what the bill does to protect those freedoms that Senator Powell, quite frankly, was asking about as well?
I mean, it goes back to Ryan Kriegshauser, Kriegshauser and I Law Group. I think it goes back to my comments at the beginning is these units of government do not like to be challenged. They don't like to have to go to court. We saw in Salina, the city council passed an ordinance basically not allowing the city to make health mandates. And that went onto the ballot and passed by a wide margin. And the city is now in court trying to make it so that they're claiming that the ordinance itself is unconstitutional, but you had the majority of the entire city vote for this ordinance, and they don't want to be challenged on it. They want to have their say and not have to respond to anyone. So I'm not surprised that units of government are in opposition to this, because it does give more rights to the parents that you've heard from who are frustrated, and they don't feel that those units of government have been listening to them over the past year, and they have just been issuing mandates that parents have been forced to follow regardless of their beliefs. And so it's not surprising that units of government, like you say, don't like this bill.
One other question. We try to oftentimes find a reasonable balance between for instance, this bill, it seems opposition is local units of government, and the other side is more private citizens and private rights and things like that. Do you have a response when I'm anticipating hearing from the opponents of the bill regarding local control and how this bill would affect that and impact that and provide the balance there, if you will, if you can speak to that?
Well, and I think that's one thing that we've seen, these units of government play games on it. In Johnson County in particular, you had, it was at the beginning of the pandemic, they said, the school board said, we have control, we have home rule, constitutional home rule authority, so let us make our own decisions. But yet, when the school board was coming up for election, they pushed it onto the county, and you actually saw some emails and news stories about this, and they said, we can't really make decisions. We have to rely on what the county health department tells us to do. And so the county health department would issue their orders, and then the school boards would go along with it. But we've always known that school boards have home rule and the ability to make some of these decisions. And I think you have seen some school districts like Spring Hill is one that has pushed the envelope and said, we're going to allow parents to make more decisions than a lot of other school boards have allowed parents to do. And so I think this bill takes into account home rule, both at the city level as well as the school board level. And that's why we aren't approaching this as taking away all authority. We're just saying you have to just try to tailor it. Don't be lazy and issue an indefinite mask order that you never have to come back and revisit. So this puts a check on them, so they have to think through the process and determine what is actually necessary. One of the we represented Jim, and I know you've heard all about this with the legislation last year, but our point in the Omega Jim case is that it was unreasonable to shut down businesses. It's unreasonable to put occupancy limits on restaurants. When you look at the number of cases that came from restaurants, it didn't make sense. And so what some of this is trying to do is, when you're looking at shutting down a business, it's not saying you can't do that. It's just saying you have to pay for it. And so now it's a cost benefit analysis of a unit of government to decide, is it worth it? And I think during the shutdowns, I think if units of government had to make that balance, you wouldn't have seen shutdowns like this. And so if you make units of government think about it and say, is it worth it to shut down all these restaurants and all these non-essential businesses? It's going to cost you a lot of money because you're going to have to pay them for shutting them down. I think they're rational actors and they'd act differently. And so there's a lot of that type of thing in this bill. We're not telling units of government they can't do things. We're just telling them there are checks on them, and they might have to pay for some of those mandates.
Thank you. One last question. Regarding the language, particularly at page 8 is one example of it, narrowly tailored and uses the least restrictive means. Those are terms of art. You're an attorney. Those are terms of art in our case law and in how courts decide, quite frankly, controversy in front of them in litigation. And is it the most strict scrutiny that a court can provide for an action that is under its review in litigation, or is there a standard that's even more strict in the civil context when looking at kind of trying to find this balance between constitutional rights and government action?
No, I mean, in constitutional law, strict scrutiny is usually looked at as the strictest test to put some kind of statute through to see whether or not it's constitutional.
And is that the language that we have when we're
Yes.
talking about narrowly tailored and uses the least restrictive means?
Yes, yeah, and so that's why a lot of our cases are on appeal. The Court of Appeals needs to weigh in on the Morris County case, for example, when the district court said an indefinite mask order is narrowly tailored. We disagree with that and think it needs to be 30 days. 30 days is more narrowly tailored than indefinite. And so these cases need to work their way up through the system and have some case law issued on them.
Thank you. Committee, other questions for our proponent conferees? Senator Thompson.
Just one quick one for Ryan. Is school board statutory home rule or constitutional home rule?
Ryan Kriegshauser. It's constitutional. The school board, local school board, home rule is constitutional.
So anything we change in statute wouldn't be able to touch that.
No. And so we've tried to keep home rule in place here and just put checks and balances on how those units of government operate. But it's constitutional home rule. Cities have constitutional home rule. Counties have statutory.
Thank you. Thank you, Madam Chair.
Is it because of the constitutional home rule of those governmental entities that we have the strict scrutiny standard? If we're going to have court review of those actions, we also need to, of course, be mindful of the Constitution in all regards. And that's why we're using the language that's, again, a legal term of art regarding narrowly tailored and uses the least restrictive means possible. That complies then with respecting the constitutional right of individuals as well as those local government units. Is that right?
Yeah, I think we are trying to find that balance. We're allowing local units of government to take action, but it has to be narrowly tailored, and there are checks on that.
That checks and balances. Thank you. Senator Baumgardner.
Thank you very much, Madam Chair. Thank you for being here today. Last week in testimony, we heard of units of government as well as school districts meeting in what might be considered executive session or simply closed meetings where majority or all of the elected body were meeting with what was described as medical experts. So can you think of any context where coma could be used in this manner for executive session if it is not for a meeting of attorney-client privilege or discussion of matters relating to non-elected personnel?
Ryan Kriegshauser, NI Law Group. Yes, we have come into contact with this. I think Salina, we're actually in a Cora investigation with, based on their meeting with a medical advisory group. Their claim is that medical advisory group had no decision-making power, and so they just told the superintendent what to do, and then the superintendent did it, and so they shouldn't be subject to coma. Blue Valley took a similar approach probably a year and a half ago on some of their sports decisions. They set up some of these advisory groups as well, and then let the superintendent basically use a gating criteria and just impose mandates based on what that criteria showed, without actually voting on the mandates themselves. And so they have taken the position that those advisory groups are not really decision makers, so coma doesn't apply to them. So I think that's something that we'll have to find out in court probably, but coma could be amended to make these advisory groups subject, because it's important. I mean, when we got the minutes of the Salina advisory group, I mean, they were recommending goggles on students. They were making all kinds of recommendations to the superintendent, and that have an impact on all the parents. And the parents should know what these doctors are saying. I mean, they were advocating KN95 masks for everyone. A number of more extreme actions. And parents should have a right to know, because it's going to impact them if the superintendent takes the mandates in those directions.
And so just as a brief follow-up, should there be something amended to our Senate Bill 541 that indicates that coma guidelines will be followed and any sub-decision-making groups must be made public?
I defer to the reviser on that. One question that we had, because we had thought about the coma issues, and I think coma could be amended to make it explicit that those advisory groups are subject to coma. It's just the one subject rule, whether or not it could fit into this bill, because arguably the medical advisory groups could come into play here, but I defer to the reviser on whether or not that could stay within the confines of the one subject rule.
Thank you, Madam Chair.
Committee, yes, Senator Pyle.
I want to make sure I understand. You mentioned back a little ways about a case. There's some cases pending. Are they being slow to react? Is there a purpose in this, or is there could they not make a decision?
No, I think some, like the Morris County case, in particular, they may claim that it's moot because they don't have a mask order right now. But obviously, these are issues of public concern, and they're capable of repetition. I mean, these things may come back.
What court is that in front of? The more
it's going up to the Kansas Court of Appeals.
And what recourse, if they say it's mute, what recourse do you have? Can you sue the court?
Well, no, we'd go up to the Kansas Supreme Court at that point.
Okay, so you would appeal higher.
Mm-hmm.
And what if they said they wouldn't take it?
That's possible. They could. Then you'd have to look at whether or not there were any constitutional issues that you could go to the federal court. But at that point, I mean, courts are adjudicators of law, and so that's what we rely on them to do. And so in some cases, when the Kansas Supreme Court speaks, it's over unless the legislature comes back and says, no, we're changing the law to make it specific. And I think that's one of the things we're trying to do with this proposal is take away these loopholes and have the legislature mean what it says.
In your opinion, Ryan, I mean, checks and balances you referred to, do you think those are similar to soft sanctions?
In some cases, but I think the prohibition on not allowing a county to issue an order that's more than 30 days without coming back and revisiting, that's something that they don't want to do. And I think that's meaningful. And I think they should have to come back, and that's pretty explicit in the bill.
Thank you. Thank you, Madam Chair.
Thank you. Committee, other questions? Seeing none, then we will thank the proponent conferees for their testimony today. And we will then have a neutral in-person conferee, Representative Trevor Jacobs, representing District 4 in the Kansas State Legislature, Kansas House of Representatives. Welcome to a committee, Representative. Please introduce yourself. And thank you for waiting today.
I am Trevor Jacobs, representative of District 4. Reading through this Senate Bill 541, just in the short, long title, on a concern to me is the religious gathering limitations shall not exceed 30 days. I want to bring some attention to something here where we read, if I can find my notes. I apologize. When we read in the First Amendment, it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And then in Section 7 of our Kansas Bill of Rights, it says, religious liberty, property qualification for the public office. The right to worship God according to the dictates of conscience shall never be infringed. And with regards of this language to this bill, I don't like the idea of giving government entities, whether it's the governor or local entities, the ability to just shut down churches. We watched this in the last couple of years where pastors were outside preaching to congregants who were inside of their vehicles, and it's raining, inclement, bad weather. You have a $250,000 or more or less church behind them in the background, and we're not able to practice our most fundamental religious liberty, and that is to gather together and worship God. I'd like to bring a quote to our attention also. Joseph Stalin said this, America is like a healthy body, and its resistance is threefold. It's patriotism, it's morality, and its spiritual life. If we can undermine these three areas, America will collapse from within. For myself, I come here on behalf of the Christian community or the religious community, that I don't believe our First Amendment liberties should ever be violated again. And I would like to see a stronger effect in this where we're not shutting down churches. We see in page 2, starting in line 37 through 43, it talks about emergency disasters, and goes to page 3 and it says limit the size of gathering of individuals or limits the religious gatherings. And then substantially burdening on line 14, burdening the operation of any religious or civic. I don't know what the definition of substantially burdening the operation of any religious or civic. We shouldn't be burdening religious activity at all or restricting it when it comes down to these issues. I do have a lot of reservation, again, with the religious oppositions in here. We shouldn't have to sign a document saying that we want to choose to live in liberty. I choose not to have a vaccination, or I choose not to have to wear a face mask. We shouldn't have to write a letter or have a passport for these things. It should be our fundamental liberty or our right to make a choice and not have government mandate something upon us like this. But there's many, many other things I could say, but I will stop there and stand for any questions.
Thank you, Representative. If you want to stay near the podium in case we have any questions for the representative, so he can get back to his committee work. And I don't know if the House is on the floor right now, but apologize for you leaving to come over here if the House is. Committee, any questions for the representative? Senator Thompson.
Thank you, Madam Chair. Sorry about that. On your way out, are you concerned or feel that codifying the terminology substantially burdening the operation legitimizes the ability to override the First Amendment rights?
I do. I think it gives an escape. I think it gives an excuse. And we don't lose our individual liberties because government deems or wants to carry on a crisis. We've been living in this COVID-19 for almost 2.5 years. And if I may, this just doesn't pertain to COVID-19. What if we're going to have COVID 2022 and 23 and whatever the next gimmick is?
Committee, other questions for the representative? Senator Gossage.
Representative, thank you so much for being here, and certainly appreciate your wanting to put liberty above mandates and having to quote opt out of a government mandate. Thank you so much for being here.
Thank you.
I also want to thank you for being here and echo Senator Gossage's comments that we have to put liberty first. Appreciate that. And without any other questions for the representative, seeing none, then thank you for appearing in committee today.
Thank you, Madam Chair.
Appreciate that. Do we have any other neutral conferees in the committee meeting room or on WebEx? Seeing none, I wanted to ask the reviser one clarification question based on the testimony we just heard when we're talking about substantially burdening the operation of any religious, civic, business, or commercial entity. One instance of that is on page 3 in the bill. Is that a legal term of art as well that you could explain to the committee and those following along when we're talking about substantially burdening, and if that term of art is used in other contexts such as employment law or other areas?
Madam Chair, I believe that we use that, and it has a legal meaning. I just can't put my fingertips on it right now, so let me get back to you on that one.
Thank you. Committee, then we will hear from our first opponent conferee, John Goodyear, General Counsel, League of Kansas Municipalities. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. Good morning. My name is John Goodyear, and I'm the General Counsel with the League of Kansas Municipalities. So I'm going to start with the home rule reason for opposing this bill, Madam Chair. Cities have been empowered by the people of Kansas with the ability to make laws. We act locally to address local problems with our ordinances. We utilize that power when we pass ordinances that are aimed at protecting the public health, safety, and welfare of our residents. We think it is more than fair to expect cities to consider all the evidence and make the best informed decisions that they possibly can at the time that they make the decision. However, we must allow cities to make these decisions, especially in emergencies. This is the level of government that is closest to the people. They're able to respond to the wants and needs of the people, and it's what they were elected to do. The League opposes this bill as a limit on cities' abilities to respond to public health emergencies. And one thing to note is that while this is aimed at COVID-19 response, it's not limited to it. We don't know what the next public health crisis, hopefully it's far down the road, hopefully it's 50, 100 years. We won't be here. You probably won't be in the legislature. I hopefully won't be lobbying anymore. But we don't want to limit forever the ability of local governments to respond in the future. We don't know what the next thing looks like. So now moving on to sections of the bill and just highlighting some questions that were presented by it. Section 1 of the bill seeks to provide a cause of action under which a person could seek compensation when the government action restricts the use of property. It should be noted that largely most of the causes that we list under governmental action are already covered by current law, whether it be federal law or state law. Under the Takings Clause, you're able to seek compensation when government appropriates private property. However, Senate Bill 541 would expand this in a way that's not necessarily consistent with current law or with actual circumstances. Governmental action is defined relatively broadly to include restrictions on use that certainly should be compensated. Absolutely. If a business is commandeered, that individual should be compensated for it. But a mask mandate, or that is applied uniformly to all citizens exactly the same. It's not treating your business any differently. It could hardly be said to be burdening that business. It's not on the same plane. Moving now to Section 2 of the bill, which has the 30-day sunset provision. But the part that my testimony focuses on is the ability to challenge the validity of the action, and specifically the heightened standard that's created in order for an ordinance or local action to be considered valid. Senate Bill 541 would impose a strict scrutiny standard that the ordinance be narrowly tailored to the proposed purpose and be the least restrictive means to achieve that aim. That is not consistent with how we typically look at laws in this country. We do have strict scrutiny is used in certain circumstances, but mostly when we observe laws and look at the validity of them, we're looking at a rational or a reasonable basis. That's the same is true for ordinances. Even though cities have home rule authority, ordinances have to be reasonable. They have to be rooted in some good reason for bringing that action. At the very least, this limit.
That's 3 minutes. If you could just wrap up that
Absolutely.
thought.
At the very least, this limit in this heightened scrutiny standard that's created presents a question. I don't know that something like this has ever been brought forward, and this may run afoul of the Home Rule Amendment. And Madam Chair, I can stand for questions at any time.
Thank you. And committee, we will hold all our questions until we have heard from all the opponent conferees. Next, we will hear from Jay Hall, Deputy Director and General Counsel, Kansas Association of Counties. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. Jay Hall, Deputy Director and General Counsel for the Kansas Association of Counties. I will be as brief as possible, as I know we're probably a little short on time. I do want to observe that one of the previous speakers mentioned it not being appropriate to delegate authority from the county health officer. But I would note that Section 7 and 8 of this bill actually do delegate that authority. They make it so that the only boards of education or governing bodies of community colleges could take action regarding infectious or contagious diseases. So I want to make sure that we understand that although one of the proponents did talk about it being inappropriate to delegate that authority, that's actually one of the things that's contemplated. And you'll see those sections highlighted at the beginning of my testimony, but I wanted to bring that up. We are concerned at KAC that this does invade local control. Obviously, while cities and school districts have constitutional home rule, counties only have statutory home rule. And so that's something that is important to us, to make sure that counties can take the action that is appropriate to address the concerns as they come out. As the previous speaker mentioned, we don't know what the next crisis will look like. We don't know what the next health concern will look like. And so removing tools from the toolbox right now, while we're kind of in the midst of COVID, when we don't know what that next challenge will be, is something that presents a future risk that we may not be here to address. And then finally, I'd like to just take the opportunity to mention that we do live in a world full of mandates. That's what the legislature does. That's what local governments do. We pass laws, we make rules and regulations. So this bill is really not about whether or not there will be mandates, because the bill itself is a mandate, in fact. But it's more about what those mandates will be, who those mandates will be subject to, and who will be able to issue those mandates. And so I'd like to leave the committee with those thoughts. And with that, I'd be happy to answer questions at the appropriate time.
Thank you. Next, we will hear from Nick Reinecker. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, and members of the committee for allowing me to speak today. My name is Nick Reinecker, private citizen from Inman, Kansas. I'm not a lawyer, and I hope I don't need to be providing testimony or understanding this bill. The senator from Wyandotte asked last time that I was here if I'm an advocate of not having a plan at all. I do have a plan, and it's called the Constitution of the United States. And then that is the Amendment 10, which gives the state of Kansas broad authority. However, it also says, or to the people. I am a local control advocate, starting with the individual and family and moving up from there. I'm not here to bash the hard work that's been involved in this bill. However, a lot of it depends on a moral, liberty-minded judicial system. But when they are expected to deal with words such as shall, reasonableness, narrowly tailored, but they can't even defend a baby in the womb, you expect me to surrender my fundamental rights for the general welfare with hopes that I'll get them back with some compensation when dealing with an illness that for many of us was just another common cold. There are Marxists in both parties, and it is incumbent upon the proactive citizenry to be proactive, to be in the meetings, the city council meetings, the county commission meetings, the school board meetings, to make sure that they're holding their elected people accountable. We should not desecrate the lives of those who have died for our freedoms so that I can be here today with my family testifying. Faith, family, freedom, liberty, morality are all academic things. It's your job to put it into practical standards to make sure that I can live my life as peaceably as possible. Specifically, and I wish we could do a little more hearing and a little more time, but I understand that it's not the case. And I wanted to point out one mistake that I may have made at 1:30 in the morning on Friday as I was trying to do this testimony. The third paragraph, section 4, letter subsection B, I think I got confused about the intentions of possibly bullying somebody. I think this was just supposed to tell the students about everything. But other than that, I want to say one thing about the mask. My children were allowed to go to school with a scrap of a Halloween costume that was a Superman cape on it. And if that is effective against the spread of aerosol and droplets, I don't get it. So I'll just leave that as it is. Madam Chair, I do have copies of the Congressional Record Current Communist Goals that I could provide to the committee if so desired. But I thank you for taking the time to have this committee hearing. And if I had 1 or 2 minutes, I would go through a little bit of the Constitution. But if not, I appreciate the time allowed to me, and I will stand for any questions.
Thank you, committee. We will now hear from Sarah Ersick Good, board member, Immunize Kansas Coalition. Please introduce yourself and welcome to committee.
Thank you. My name is Sarah Good, and I am here on behalf of the Immunize Kansas Coalition in opposition to Senate Bill 541. And this is difficult for me because if I take this name tag off, then I'm simply a mom of a 13-year-old girl who has struggled with the application of public health best practices in a school and other youth settings. Over the last 2 years, we've dealt with depression as a result of social isolation. The early lockdowns took a grave toll on her mental well-being. She was quarantined from school unnecessarily 3 times in 1 semester because a positive antibody test was not accepted as prior proof of infection. She overcame her fear of public speaking in front of adults and has spoken at every school board meeting when the mask mandate or in-person learning decisions were on the agenda. And I've held her in the nurse's office as she sobbed as she was forced to pick the lesser of 2 evils, quarantine and isolation at home or stay in school with a mask through the Test to Learn program. That's the story I really wanted to tell you today, but I can't. I think it's important for you to know that I identify very personally with every proponent of this bill today and last week. But still, I am here today with my name tag on in opposition to this bill as it is currently written. which would have far-reaching implications beyond COVID-19 and beyond my child and theirs. Specifically, the new Section 4 and Section 15 redefine religious beliefs as theistic and non-theistic, or any belief that is sincerely held with the same strength as a traditional religious view. When you redefine religious belief to mean something other than an actual religious belief, rather than adding a philosophical or conscientious objection of its own, you impact every public health provision that currently allows for a religious exemption, not just COVID responses and not future responses. Under the proposed redefinition, philosophical objections would qualify as religious exemptions to the current required wellness vaccines for childcare and school entry. It is important that the implications of that change don't fly under the radar, overshadowed by the very real pain and suffering that you've heard this week. I use the term wellness vaccines very intentionally so that you know that I'm talking about current childhood vaccines with decades of proven success and safety, vaccines against things like measles, mumps, rubella, polio, and pertussis. The term wellness vaccine does not include COVID vaccines. Historical amnesia of the consequences of vaccine-preventable diseases has fueled hesitancy. So considering the preponderance of evidence to support childhood vaccines, Kansas voters overwhelmingly support the current statutory definition. A recent statewide public poll of Kansas voters, which I've linked for you in my written testimony, found that 91% of all voters across party lines support the existing wellness vaccine requirements for child care facilities, and 61 to 65% of Kansas voters would like to see a tighter application of the religious exemptions, not a redefinition of that term. So as such, I would encourage you to strike those specific provisions from the bill as you work it in committee, or at least clarify that the philosophical exemption, not a redefinition of religious exemption, is only related to mask mandates. Thank you for the opportunity, Madam Chair and members of the committee. And in summary, we oppose Senate Bill 541 as it is currently written. Thank you.
Thank you. Are there any other opponent conferees in the committee meeting room or online? Seeing none, then want to draw your attention to opponent written only testimony from Dennis Kreisel, Executive Director, Kansas Association of Local Health Departments, Carla Nichols, Director of Public Health, Reno County Health Department, Lynette Reddington, Director, Harvey County Health Department, Stuart J. Little, PhD, Little Government Relations on behalf of the cities of Prairie Village, Mission, Merriam, and Westwood Hills, Jennifer B. McKinney, MD, FAAFP, Kansas Academy of Family Physicians, Allie Hilton, Director, Nurture KC, Mark Tallman, Associate Executive Director, Kansas Association of School Boards, Dina Horst, on behalf of the Kansas State Board of Education. We also have opponent written only testimony, though the written copies are not in your committee folder, from Timothy R. Graham, Director of Government Relations and Coalitions, Kansas National Education Association, Susan Wood, Douglas County resident, Michael R. Miller, MD, and Chris Rosel, MPH, MS. So with that then, committee, we will open it up for questions for our opponent conferees. We did have 26 minutes of time for questions with our proponent conferees, so we will have that same amount of time for our opponent conferees. And do apologize, we have run a little bit over time for committee, and open it up for any questions. Seeing none from the committee then. With that, then, we will close the hearing on Senate Bill 541, and that helps keep us closer to on time in committee, so there you have it. Committee, want to thank your work and your attention today, as well as those in the committee meeting room, those who have testified in person and traveled to the Capitol today. Thank you, and as well as those following along online and who may watch subsequently. So this is an important issue that we have been looking at and living through, particularly for the last 2 years, and want to thank everyone's attention as we continue to look at the issue as we have the bill before us. Thank you very much for your attention, and we are adjourned.